Good morning, Adelaide, and indeed the universe. My name is Con, and I am the Conversationalist. As always, my latte in tow, back from a week off with a new granddaughter. God bless my little pumpkin. She's so gorgeous, Edie. Good morning. This morning, my guest is Suzi Cengarle, and Suzi is a senior associate at Bambrick Legal here in Adelaide. Suzi was admitted as a practitioner of the High Court in 2013. Lawyer of the Supreme Court 2013, barrister and solicitor of the Supreme Court 2013, and has a Master's of Legal Practice 2016. And Suzi specialises in family law, estate planning, particularly property settlement, children's matters, testamentary trusts, wills, probate, and estate disputes, of which I'm sure there are plenty. And Suzi also tells me that she could be a grandmother any tick of the clock. So if Suzi disappears very quickly, we'll understand and we'll know why. Good morning, Suzi. How are you? You there, Suzi?
Very well, thank you. My daughter-in-law is in labour as we speak, so yes.
Oh, really?
It could happen any minute, actually.
Oh, goodness me, goodness me. Okay.
All right, they are in Victoria, so I won't be able to see my cherub quite as soon as I was hoping, but it is what it is.
Yeah, no, that's unfortunate for Victoria, but never mind. Suzi, you also mentioned in when we spoke earlier that you speak Italian fluently, but also there's you've a bit of French there. Where does that come from? School.
I did year 8 French, but I've used it ever since from time to time. Oh, sorry, my dog's just wandered in. He makes himself at home. My dog is part of the staff, and he's just wandered in. I wondered who that was, ignoring my sign on the door, which said "Do not come."
That's right. Dogs can't read. There you go.
No. So yes, I learnt French at school. I was raised in an Italian family, so that's where I learnt that. And look, French gets me around France. I can order meals and have very basic conversations.
So on a scale of
I've got a couple of other languages I don't know.
On a scale of 1 to 10, where does your French sit?
Oh, probably 2. Oh, probably a bit better than that. 3 or 4. Yeah, it's not great.
So I was going to say, so you can't order really good meals. You can just order.
Oh yeah, food. Don't worry. You can only see my face, but I'm okay with food.
That's all right. Okay. Suzi, let's go back a little bit. Again, in the information that you sent me, you mentioned that you were a paralegal for 30 years. You were running several businesses. You were temping out as admin, but you've then taken the next step to become a fully fledged solicitor. And even before we started recording, you mentioned that you don't like them. So what prompted you to go from being a paralegal and doing other things to actually becoming something that you openly don't like?
Yeah. Well, I had a change of life. I separated from my then husband. At that time, I was indeed studying HR and management, business management. And then I met my current partner, who's also a solicitor, and he needed a PA. He was working from home at the time. He needed a PA/office manager on a part-time basis. And because I was studying full-time and only looking for a bit of part-time work, and we were starting to date and looked like that relationship might be going somewhere, I said, yeah, sure. I took the leap of faith. So I stopped working full-time, started working for him part-time and studying full-time with a view to, once I finished my degree, I would transfer into being a solicitor, which is indeed what happened. And because employ someone else to do the admin, and so we've gone from that, as in working from his home kitchen table, to Bambrick Legal and what it is now, with 4 practitioners on board and a team of admin. We've got a team of about 8 at the moment. We're currently recruiting. So awesome. We're growing as a business as well. So yeah,
good.
That was it. So after I started studying law, I went, oh, actually, I quite like this. Yeah. Still don't particularly like many solicitors, but learning how to manage them has been interesting.
I was going to say, definitely your HR skills and people skills would come into play quite
Definitely.
significantly to deal with the personalities, because as you said before,
Absolutely.
they and look, from a legal perspective, you need to be a strong, I guess, strong communicator and assertive. So we need to be able to manage those people. So we mentioned that you're in your bio there that wills, estates, and testamentary trusts. Just in a few words for the uneducated here, what is a testamentary trust?
Okay, I could deliver a 2-hour lecture on that, but I shan't.
But you shan't, because you've got a baby on the way.
No,
grandchild.
that's right. Literally.
Yeah.
No, well, what it is, it's the way I advertise it to my clients as such, or the way I talk to my clients about it. It's a will that's on steroids. Everybody understands your standard everyday will, where husband and wife leave everything to each other, and then when they're all gone, everything goes to their kids, and everyone's happy with that story. Nowadays, we've got blended families, we've got people running businesses, we've got people who are directors of multiple companies, etc., etc. More than one relationship, children from more than one relationship, 2, 3, and even 4. So how do you start to cater for all of those? Well, you can still go to your standard will, which still works for everyone, but it does open you up to a little bit of risk when it comes to people wanting to make a claim on your estate, because disappointed beneficiaries, people who think they should be getting something or getting more than what they're actually getting, that's where the fun starts. With a testamentary trust, what it does is it protects the asset not only from each other, all of the other beneficiaries, but also from outside attacks. So, for example, the trustee in bankruptcy, it protects people who are running their own business, but it also protects people who are in a relationship, which then ends up in the family court. So if there's a separation. So what people sort of try and get their heads around is like, I want one of those now. I'm a business person. I would really love a testamentary trust to be able to operate it now. That's not possible. A testamentary trust is called that because it is enacted or effective or commenced on the death of the testator. So the will maker writes a will, a normal will, which leaves everything to whoever they want to leave everything to, naming executors, naming beneficiaries, naming guardians for children if required. And then on the back of it is tacked on this testamentary trust. So the will creates the trust, but the will does not become effective until the person dies. So a testamentary trust will is for the benefit of your beneficiaries, your children, your spouse, not for you in your current business while you're alive. So to put it really bluntly, you have to die for someone to get that advantage.
Sure. Okay.
So it's complex, it's complicated, but it's really beneficial for a will maker whose children or beneficiaries are either running their own business, so they're at risk of attack for the trustee back or negligence or something like that, or they've got children who are in a relationship that might be a bit wobbly and the parents aren't confident that it's going to go the full distance. So it starts to protect the assets for their children and their lineal descendants rather than exes and bankrupt trustees and anybody else grabbing it. That's really where it's about. And there's some tax benefits as well that you can distribute greater amounts to minor children, blah, blah, blah. Anyway, it's a long story, but but really well described. A will on steroids. Yeah, really pretty much.
Good. Okay. Let's talk super. Now, at the moment, you have to make a binding nomination on your super. Now,
you don't have to.
Well, okay. So my understanding is that in your will, for example, mine's really, really simple. Everything goes to my kids, and that's pretty much it. But I understand, or I'm led to believe that my super does not go into the pool. Let's say it's actually at the discretion of the trustee of the super fund. So why is this so?
Okay, so I can't give you financial advice. Let's just be really clear
absolutely.
on that.
Yep, no,
okay?
Absolutely. No.
And I know you're not asking me for
no.
advice.
And just let me interrupt. Just let me interrupt very quickly. Sorry. and this is for the benefit of the viewers, this is indeed, there is never any intention for legal, financial advice of any way, shape or form. This is general discussion, a total disclaimer. And if you have any questions, you should seek legal advice, professional advice, tax advice, whatever advice you need. This is in no way, shape or form any formal advice. So, Suzi, continue.
That's absolutely right. And if a client of mine does speak to me about their superannuation, I can give you a general overview of what happens at your death, depending on what you've got in place. But I always refer them back to their own financial plan.
Absolutely.
Find one.
Okay. So let's just go back in general.
But in general, the way it operates is that your superannuation fund, whether it's an industry super, self-managed super fund, or something else, they give you the opportunity, if you wish, to indeed name binding death nominees. They're getting better at the way that they deal with that, but once upon a time they gave no advice, and so people were actually naming anybody they felt like, nieces, nephews, the neighbours, cousins, whoever. In actual fact, the trustee of a superannuation fund will not pay out to anyone other than specific categories of people who are allowed to be named as a nominee on your binding death nomination, and that is your spouse or de facto, your children, and stepchildren kind of fall into that category if you're still married or still with that person at your death, as in your partner. Adopted children, and someone who's dependent on you, so maybe a parent, or somebody like that, they fall into the category, or your legal personal representative. If you do not name anybody at all, it forms part of your estate and goes through your asset pool through your will. So it actually, like any other asset that you've got on your death, your superannuation will be added into that pool and paid out to your estate rather than to one of the people that's been named. If you've named somebody other than one of those persons in that category, then it becomes a problem, because you need to prove to the trustee of the superannuation fund who that person is and whether or not they're an eligible person. And if they are ineligible, then it ends up going back through your estate anyway. If you have named someone who is eligible and appropriate, and the trustee in your super fund agrees that that person is eligible, then that asset no longer forms part of your estate and gets paid directly to that named person. So when we do an application for probate, we normally have to go through all of the assets and liabilities of the deceased. And the question is super in or out? And the answer is depends. And it depends on whether you've got a binding death nomination that is actually valid, and that is that it's that you've named one of those eligible people. If you've named somebody outside of that, then it becomes a problem. So don't expect your super fund to necessarily guide you, because they're just ticket flickers generally. Speak to your financial planner, and if you have got a financial planner, they ought to speak to your solicitor when you are preparing your estate planning documents, because there is a lot of crossover as to assets, including life insurance policies. They fall into that same category as the super fund.
So in really broad brush terms, and again, viewers, this is not financial advice, or get your own. Correct. In broad brush terms, if Mr. Smith has a couple of kids and there's no one else, there's no other complex relationships with regards de factos and someone else's kids and goodness knows whatever else, and everything's going to his kids, there's not really any benefit or any advantage to making a binding nomination, or he should still.
The only advantage is, there is an advantage, and that is when you make your application for probate, the filing fee that the court charges is dependent on the value of the asset pool. So your superannuation, if it's significant, and even a couple of $100,000, can tip you into the next asset pool. So if your asset pool is worth less than 200, let's say, then your filing fee is around the $800 odd. And then you've got graduating steps along the way until you hit $1 million, and that's the cutoff. So if it's 1 million or over, then it's a $3,000 odd filing fee. And there's a couple of steps along the way. So let's say your asset pool is sitting at about 500,000. If your super throws it into 700,000, So now you're into the next bracket.
Yeah,
Whereas
okay.
it's not in, it's in.
Okay.
So you might save a couple of $1,000 at your estate will save a couple of $1,000, and that goes to the kids rather than to the court. So
okay, yeah,
that's probably a real financial advantage.
Okay, so viewers out there, it's not cut and dry and really simple. For the fee that your professional person is going to charge you, it's really, really important that you get professional advice based on your specific circumstances and the outcomes that you're looking to achieve. Is it a fair comment?
Absolutely.
Good.
And don't do a homemade will ever. I can tell you a story about that.
Okay. Well, if you're happy to tell us a story, we're always happy to hear a story.
A real quick one.
Go on.
A real quick one. I had a client whose mother was Lithuanian and decided to do her own homemade will. Some of you that are children of migrants will probably associate with this one. She named her son, her only child, who was a police officer at the time, as her executioner. I'm really pleased to announce that he did not carry out that role. In fact, he was the executor, but she did name him as her executioner. It was a handmade will. It was all over the shop. It wasn't signed properly. And throughout her life, she'd been married half a dozen times, so she had half a dozen names along the way. So when it came time to making the application for probate, not only did we have to let the registrar of probates know that our client was not in fact an executioner, he was only an executor. And also we then had to do a very long affidavit of identity for her, because she just kept on changing. So sometimes her first name was spelled different to her surname. Yeah, it just kept on changing. So we had to put on birth certificate, migration certificates, passports, expired passports, marriage certificates, divorce certificate, marriage certificate, divorce certificate. It was just this huge big long document. Would have been a lot easier if we'd tidied it up in the will in the first instance. Yeah. Because you can put, so-and-so, also known as whoever, and we could have got a whole heap of stuff done. Okay. Anyway.
All right. So there's another lesson to the viewers. Don't do homemade wills.
And if you do, don't name an executioner.
Very good, very good. All right, let's have some fun. Let's talk prenup.
Oh yeah. Happy to talk about that.
Oh, prenup. They fascinate me. So obviously the benefit of a prenup is pretty obvious. You're protecting your assets. If one party is let's say particularly wealthy or whatever. So the reason there is obvious. How binding are they? Because everyone's challenging everything, aren't they?
Oh, absolutely. It's called a binding financial agreement in Aussie speak, as opposed to a prenup, which is what everyone understands it to be. Being a binding financial agreement as opposed to a court order, it's easier to have it set aside. Well, how do you have it set aside? Well, the usual contract issues, as in duress, fraud, or you've entered into it to defraud somebody else, or you haven't been completely candid with each other, so one person finds out that you haven't been completely honest, or you haven't discovered or made the other person aware of all of your asset. But assuming that you do everything properly, so you do have a list of assets that you both have that you bring into the relationship, and that you want to preserve those specific assets, it gets more complex the longer the relationship goes on. So if, for example, you enter into a prenup now and you separate in a couple of years' time, your asset pool may have grown, but it wouldn't be a significant growth. So, I owned a Mazda 3 before I met you, and I want to take it with me, no dramas. We bought this house, I put in $100,000, you put in $0, I'll take out $100,000, and whatever equity we've acquired, we'll split. So that's pretty easy. But as the relationship grows and takes more time, once you hit sort of the 10-year mark, some of those initial assets may have been sold and new assets purchased jointly, separately. It gets a bit muddy. It does get a bit muddy, and it's not uncommon for, not so much that it is set aside, it can still have some weight, but it becomes grey as to what are assets of the relationship that have been acquired during the relationship, and then you have to apply the usual approach for asset pool distribution. And without going into a whole heap of stuff, you talk about initial contributions, and then financial and non-financial contributions and valuations, and then we work out who gets what. That starts to come into play the longer the relationship is. A very well prepared prenuptial agreement, binding financial agreement, will hold a lot of weight. And quite often parties that have entered into something like that come to the end of their relationship and they will say, well, yep, we'll stick with that. Those that feel like they've been hard done by for whatever reason, that's when it gets nasty. Not necessarily a gender thing, but if you feel like,
partner,
you've been hard done by, whatever, then people get a bit more assertive about what they want. And are inclined to ask for a lot more maybe than what they're entitled to. So how effective are they was your question, or something similar to that? How strong are they? The longer the relationship, the more watered down. That's quite true. But then again, if it's been a longer relationship, there's probably a better chance it'll stay together longer. But you can definitely rely on that document when it comes to speaking to a judge about, we haven't come to an agreement, we're going to rely on this. This is what we had. There's evidence of what people brought into the relationship. But things that change also is things like, introduction of children. One of the parties staying home to raise the children while the other party goes off to work. That contribution counts. It does count. So
in a perfect world, where both parties have really good communication and they're open and honest with each other, would it be advisable or recommended that they revisit we'll call it the prenup just for the sake of the conversation, revisit the prenup as time goes on? So say,
no question. Okay,
5 years time, we've been together, this is going really, really hunky-dory, let's sit down and have another conversation and redo another one. So
absolutely.
Obviously the more recent the agreement, I would suggest, would be more watertight or airtight. Is that fair to say?
Correct, because it's a more recent record.
Okay.
And the beauty of a binding financial agreement in the legal world under the Family Law Act is that you can enter into one of those before, during, or after, at the end of a relationship. We don't promote them at the end of a relationship so much because they can be set aside. Whereas a court order, so if you still can come to an agreement and the cost is about the same. You just march on down to the court with your agreement and get them to rubber stamp it. Judges don't like to set aside their own orders. They don't like to think they've got it wrong. So if you've gone to the court and said, we agree to all of this, and then in 2 or 3 years' time you go back to the court and say, actually, we've changed our mind, the court's going to go, well, at that time you were pretty sure about what you wanted, so we're not really keen to get rid of it. Whereas an agreement, the court says, well, we've had nothing to do with this. Let's have a close look at it.
So, fair call.
But your idea of revisiting is a very good idea. Excellent.
Geez, there you go. You heard it first here on The Conversationalist from a certified legal practitioner. I've had a good idea. There you go, folks. So if you've got a prenup and you're all going along hunky-dory, tickety-boo, don't just assume it will always be that way. Have a conversation and revisit it. And I guess my attitude has always been right, wrong, or indifferent, that if somebody in a mutually beneficial relationship isn't prepared to have a conversation or revisit those things, there's probably something under the surface that's not quite right. That's my view. Suzi,
this isn't about love, it's about practicalities.
Yeah, well, that's the thing. So which takes me on to my next point. Love crazed people, the first thing they want to do, and sadly guilty of it. What advice? And like, you've got grown-up kids. What advice do you give them about, their partners or lovers moving in? It's again, from a practicality sense, it can be solved quite easily, but everything's wonderful when, the calm seas, but the trouble starts when the water gets a bit rough. So, what?
And so, look, if you've got a couple, and you're right, Con, if you've got a couple of kids who start out with nothing and get in, start living together, and they bring in nothing into the relationship and grow it together, no real point, because you're not trying to protect an asset.
Sure.
It's more about the parents making sure that their estate planning's in place so that their children get it, not the exes as such. So that's important from that perspective. If your children are older and maybe a second relationship, or they've got a reasonable sort of asset pool behind them and they enter into a relationship, then I would recommend very strongly that not only do they make their own estate planning watertight, but also this binding financial agreement needs to be clear. I'm finding that a lot of migrants, and I don't mean to sound racist because I don't think I am going to be, but what I'm finding is a lot of, particularly people from Asia, where there's in many cases one child of their relationship, and those children are now growing up. So we're finding that parents, particularly with the Chinese, are purchasing properties for their children. And sometimes the children are in a relationship or they're not. And the parents are really keen to protect their child's interest in that property. We can do a whole heap of stuff around that. For example, a loan agreement between the parents that never needs to be paid until such time as a parent makes a demand for that to be paid. And that can get registered on the certificate of title. So that will then protect the parent's initial contribution to the property, which is usually a gift. But what they're concerned about is, we're in a relationship now, we're happy, we're doing well, but he hasn't put anything into it, or she hasn't put anything into it, or his or her family hasn't. It's been my family that's made almost the entire contribution. So I need to protect that, because what if the relationship falls over? So we're getting quite a bit of that, where people are entering into loan agreements with their parents or some other person that's provided funds. And that then protects, at least, even though the property is still in the name of the child, because potentially the parents don't have sufficient status on their visa to actually hold property, they can register a caveat on the property. So even though it's not an interest in the property, it's a caveatable interest, which means that that caveat will only be removed upon repayment of the loan, or if the parents decide to remove it. So that's a little protection mechanism that I'm putting in place for quite a few clients, actually. Even though I said predominantly Chinese, and it is, anyone that crosses my path that says, what do I do to protect a gift from my parents, that's the way to do it. Because if you get to the end of a relationship and say, oh, but my parents gave me X, unfortunately the Europeans were doing that for many, many years, and the courts cottoned on to it's a loan of convenience as opposed to a actual loan, because the courts have this general view of a donation or a payment by a parent for a child is a presumption that it's a gift. So unless you've got documents to protect that in place at the time that it occurs or shortly thereafter, it's pointless putting in a loan agreement 10 years down the track for something that happened 10 years ago, because the court's going to go, hang on a minute. And I've seen some dodgy documents that I'm sure have been predated and stuff like that, but that's the way to do it. And once it's registered on the title, shortly after it's happened, it then gives the court an indication of time. If it's happening a week before they separate, well, then you start to question what the motivation was.
And I can tell you, like viewers, again, take heed. Even Europeans, like I've got a good friend of mine that his parents provided some funds as part of the relationship, which was not intended to be split. And when it went to court, the judge said, well, guess what?
It's presumption.
You have half, she has half, end of story.
Yeah,
so,
it's a common story.
Yeah, and look, the sad reality that there's a high percentage of marriages and relationships that don't work. And I was speaking to a lady very recently who's a relationship trauma expert and deals with a lot of relationships that are ending. And she mentioned a statistic where I think she said second marriages actually have a higher rate of failure than first marriages. Yeah, which I found quite interesting and a little frightening. So I guess the message here is that we need to put practicalities, we need to look at things in a practical sense. It can't be love is blinding.
No.
There needs to be practicalities in place. And, and I urge anybody, again, I'm speaking from personal experience here. I was having a conversation with my son about, my little faux pas. Guys, it's you just got to protect what you do, and you've got to be able to have honest and open conversations. Suzi, one more before we go, because I know is it your daughter-in-law that's in labour at the moment? Daughter-in-law?
That's right. Yep, daughter-in-law.
Beautiful. Obviously, family matters, and where there's children involved, they're obviously very, very highly emotionally charged environments, and invariably, right, wrong, or indifferent, everyone's got their point of view, and hence why lawyers exist, because everyone sees it from their perspective and not necessarily from a level playing field, so to speak. How do you rationalise this for your clients when you've got Mrs. Smith that's come to you and she's all fired up for whatever reason, and she wants his kidneys, his body organs, and God knows whatever else. Yeah. But in reality, from a legal perspective, that she's not going to get both his kidneys and his liver and God knows what else. Right. How do you what sort of conversations do you have to rationalise and, I guess, instill some calmness into them for them to be able to make, because emotional decisions are flawed as far as I'm concerned. I've always said it.
No question.
Any decisions based on pure emotion are flawed. So how do you get them to a point where they can not necessarily remove all of the emotion, but be rational and pragmatic about it?
As soon as I start talking about my fees, that sort of sometimes snaps them into sensibility. Because quite frankly, as a practitioner, as soon as someone says, it's the principal, we just go cha-ching, because principals cost a lot of money. Yep. So that's one approach. I got to write that one.
I got to write that one down, Suzi. Principals cost money.
They do. They absolutely do.
Cost money. It. Yep, I bet you do.
Especially, yeah. And what we do is we talk to our clients, or I talk to my clients about, cost versus benefits. Everybody understands, the old SWOT analysis. But I talk about what's the costs versus the benefits. So you're arguing with your ex over $45,000. Let's say that's the asset pool. And I've had people coming in with that much money at stake. And I will say, well, your legal fees to take this to court is going to be more than what you're going to get out of it. Why bother? You're better off sitting down, talking to your partner and coming to an agreement, and then simply coming to me to draw up the documents. So that's one approach. Approach number two is, try and get settlement in place very soon after separation. The closer you do it to separation, the kinder you tend to be, because as soon as you work out that there's another person on the scene, or whether that was before or after the relationship is irrelevant, as soon as a third party becomes known, then people start to get cranky.
Yeah.
So I try and express kindness to people. Be kind and think about what you want out of this. We can drag this out through the courts. It'll take a couple of years. I've got a file in my cupboard at the moment. We made the application just before COVID hit. It was in April. We made an application for property settlement. The hearing's not until the 21st of July. So that's the first hearing. So it takes a long time to even get in front of a judge, to even get your first hearing. I can tell you in that particular, there's been no responding documents, so that's going to get dragged out for another 6 weeks at least to give the husband time to do documents. So it's messy, it's long-winded, it's costly. If you've got an asset pool of more than $1 million that's at stake and nobody wants to give in, well, then it's probably worth getting a judge involved because you're going to still get some money out of it. Trying to calm people down is difficult. However, I've got a box of tissues on standby at all times. Within reach, and it's all about
a compassionate lawyer.
Yeah, and it's about, I sort of have conversations with clients about, is it worth fighting for every spoon and every fork, or is it worth forfeiting a little bit to get this out of your life, and then you don't have to deal with that person and you get on with something? And I give the example of when I separated with my ex. I knew that I had entitlement to super. He had a much greater super pool than I did at the time, and I thought, you know what, it's just gonna, we're at a point where we're pretty well settled. That's the only thing that's left. And I just said to him, keep it. I forfeited for myself my interest in his superannuation, because I knew that that would just, you know, tip the whole thing over and make it much worse than what it was. So I talk to clients about, are you prepared to forfeit something? And the other conversation I have with all of my clients is, doesn't matter who gets what out of a relationship, no one's happy. Because the person who's having to pay thinks they're paying too much, and the person who's receiving thinks they're receiving too little. And that's a fact. And I say that at the first interview, expect that you're not going to get what you want, because you'll never be happy.
Wow.
And that's
brutal
a fact.
Honesty.
You can't do it any other way. You know, how many people I've had come through, I owned 3/4 of the house before I even met him or her, and now I've got to give him or her half. Yeah, well, you're in a 20-year relationship. There's children, people have stayed, you know, so let's just be a little bit more realistic. You know, he or she slept with someone else, they shouldn't get anything. We don't care who sleeps with who. That's not the way it works. We really don't care. You know, people like to tell me about the affairs that their exes have had. It's like, lovely, interesting story, but not relevant.
I was just going to say, yeah, the magistrate really doesn't care, does he?
Not in Australia.
No.
We're not in that country. We're in the country where it's like, sleep with whoever you want, as many as you want. Here's an interesting fact. Did you know that you can only be married to one person at a time, but you can have as many de facto relationships going in the background as you want?
Wow. So you can be married to only one person.
Fact.
Only one person.
Yeah.
Right.
You can only be married to one person.
But multiple.
But you can have as many de facto relationships.
Multiple.
So when you hear people of having other families in another state, etc., that's a thing. That's an actual thing. And
wow.
Yeah. People have entire families interstate. I can name names, but I shan't.
No. You're right. You won't.
No, I won't. But people that, not my clients, obviously, but yeah, fact, and it's been in the paper and all sorts. But you know, if you've got, the definition of a de facto relationship is quite long. There's a checklist of heaps of stuff. However, if you meet enough of those, you could be in more than one de facto relationship. So if all of those relationships split up at the same time, you might find yourself in property settlement negotiations with 3 or 4 or 5 people all at the same time.
Do you know the really fascinating thing about, I struggle to maintain one relationship on an even keel. I kind of, in a dark way, I admire these people that have the intestinal fortitude and the patience to actually have it. Like, really, ladies and gentlemen, please, it's just,
and it's not about having an affair. It's not about having an affair. That's not a de facto relationship. It's significantly more than having an affair. You know, just sleeping with someone, that doesn't define as a de facto. But yeah, people have entire families interstate, children, the whole lot, and how they explain Christmas and birthdays and I don't know how.
Yeah, weddings, christenings, bar mitzvahs, God knows whatever else.
How? I don't know.
Fascinating. There's
hard work.
I was just going to say, God, the emotional energy that's involved in keeping all that, you know, is just defies logic. Like I said, I'm struggling to keep one going on it. Like, no, I don't either. Suzi, it's been an absolute pleasure. Very, very enlightening, very entertaining. I've certainly learnt something, and I'm sure the viewers have. And again, on a very serious note, anyone watching this, please, this is never ever intended for legal advice, professional advice in any way, shape or form. You need to make decisions that are right for you, and you need to get professional advice that is specifically related to your circumstances. The discussion Suzi and I have had is a general conversation about things, and is not intended for professional advice. Suzi, free plug, Bambrick Legal here in Adelaide. family practice growing. If you've got any questions, any legal matters that you want to explore, and certainly family law, wills and things like that. It's I've known people that haven't had a will, and it's messy and it's ugly, and for what it's going to cost you, you know, the peace of mind that it will provide, you know, your heirs, for the people that want to get, for the people that you want to receive your assets. And I don't know what happens in the afterlife, but you don't want to be rolling in your grave worrying about somebody that got something that you didn't want them to get. Fair enough, Suzi?
Absolutely.
No worries. Suzi, again, thank you very, very much for your time. You have a wonderful day, and all the best with the impending birth of your grandchild. It's an absolute wonderful experience. I've got two of my own, and they are absolutely cherubs to the nth degree. Ladies and gentlemen, my name is Con. I am the Conversationalist, and from the Salubri Studios at Clarence Gardens, it's goodbye for now.
Bye-bye.